Good morning, everybody. Thank you for joining us. We are just going to wait a couple more seconds until most of us make it in from the waiting room. And well, the last few folks are taking a couple extra minutes, but we're going to go ahead and get started. Excuse me. Thank you for joining us today. I'm going to start us off like I usually do, which is with some Zoom housekeeping tips. The first of which is if you could keep yourself muted during the Zoom unless you want to unmute to ask a question, that would be great. You are welcome to do that if you want to unmute and ask a question verbally, that's totally fine. But otherwise, if you could stay muted, that would be great. You'll find your audio and video buttons on your Zoom toolbar, wherever that is on your device. And the chat button is also there. That might be flashing because I just put a message into the chat. The chat is for questions or requests for clarification only, not for commentary or, legal arguments. We haven't had anything like that in a long time, but we still like to remind folks periodically. The message that I just put in the chat does tell you how to email us questions. If you think of one that you would like us to cover next week, just make sure you get that into us by 4 p.m. on Monday so that we have Tuesday to research and prep our answers before our Wednesday morning Q&A. And also do remember, and the link is in the chat for this, that all of our videos go up on our YouTube channel within a day or two of, most of the time, within a day or two of each Q&A. And that's a great way for you to catch up on recent topics, legislative changes, or even, excuse me, search by topic if there's a particular subject matter that you're interested in looking at previous videos about. I also would like to remind you, like we do every week, that we are here to give general information, not legal advice. So if you find yourself sending us really specific or detailed questions, including providing excerpts of your specific governing documents or drafting questions that are multiple paragraphs long, you're probably asking a question that is too specific for this venue. And Chelsea will often run those questions by me. And so if she emails you back and says it's too specific, don't blame her, blame me, because I'm the one that makes those judgment calls. Whenever we can, if the question is too specific, we still try to cover the topic generally if we think it is broadly helpful to, a large number of community associations in Washington State. Sometimes the questions are just very, 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 very specific and not broadly helpful at all. And in those scenarios, we won't cover the topic at all. Please also keep in mind the videos that I mentioned, which are on our YouTube channel. The last several weeks, we have started each of them with like a little primer on some of the legislative changes that we can expect starting in this July and going forward from there, just depending on the subject matter. You can email info@condolaw.net. Also, if you have any suggested topics for those primers. So for example, we did one on executive sessions and we did one on the collections notices changes that are coming up for most communities. Well, no, for all of us, January 1 of 2026. And we've got a question on that particular topic to start us off today. So we'll be discussing that more today. And if you have additional questions, like I said, you can go ahead and put those into the chat. Another announcement is that CA Day is coming up in October, and the cutoff for submissions, like topic submissions, is the middle of June. So if you have any suggested topics that you would like us to present on, you can email those suggestions to info@condolaw.net. This is probably the last week that we'll say that because we can't take a suggestion in 24 hours, turn it around into a quality presentation pitch to send to WSCAI. But we hope that we'll see a lot of you guys there. And if you have any suggestions for us, let us know. We are not going to hold a Q&A on July 2nd. So this is a little bit of advance notice because I know that's a month away. And that's probably not very surprising to most of you because that is 2 days before a federal holiday. We will probably end up taking 1 week off each month this summer, and we'll let you know several weeks ahead of time as each of those weeks approaches. So July 2nd, we're not going to do a Q&A. And just as a reminder, the changes to WUCIOA that were made in this year's legislative session apply for WUCIOA communities starting this July, with very few exceptions, and we can talk about that more later. The changes to WUCIOA for non-WUCIOA communities, almost all don't take effect until WUCIOA for all takes effect January 1 of 2028. There are some exceptions to that, and we're going to talk about those in more detail today. The biggest one is the meeting section, and the next biggest one is the collections notice question. But we've just been getting a lot of questions about, like, it looks like a lot of changes take effect in July, and when do we have to worry about this? And so if you're not a WUCIOA community, for most things, you don't have to think about this until 2028. We're going to talk about the exceptions to that today. If you are a WUCIOA community already, then the changes to WUCIOA for WUCIOA communities take effect in July of this year. And with that, unless Katie, you have anything you want to add, I'm going to jump into our questions. Okay, go ahead. I will go ahead. All right, here's the first question. It's kind of a long one, so bear with me. I am seeking clarification on Senate Bill 5686, which requires that we send a notice of delinquency no later than 30 days after an assessment becomes past due, including a pre-foreclosure notice of delinquency with the statement, this notice is one step in a process that could result in your losing your home. We currently send a friendly reminder notice when an owner is 15 days late, and a demand letter when 60 to 90 days, which mentions legal action. Today, I issued 33 reminder notices. Only 8 accounts are over 30 days late. The remaining 25 are less than 1 month. If I understand correctly, even these 25 accounts must now receive the formal NOD with the required language threatening foreclosure instead of the friendly reminder. Is this true? If so, I seriously doubt my boards will agree to it. Threatening owners who missed a single payment by 15 days because they were on vacation or had an ailing family member or simply forgot is a way to create problems among owners, not resolve them, and the boards will know this even if the state does not. What are your best suggestions on how we convince the boards that following this state mandate for all past due accounts is in the best interest of their association? I hope I'm misunderstanding, and any clarification you can bring would be helpful. So to answer the question of whether you're understanding this bill correctly, the short answer is yes, you are understanding it correctly. It is true that you are required to include a copy of the pre-foreclosure notice of delinquency with the first written notice to an owner that their account is past due. And one thing I want to point out is that this is not a new requirement. This has been true since 2023. In 2023, so in 2021, the statutes first changed to require that a pre-foreclosure notice of delinquency be mailed to a unit owner at some point in the delinquency process. In 2023, that statute was updated to require 2 pre-foreclosure notices of delinquency. And in 2023, it was changed so that the first one was required to be included in the first written notice to an owner of their past due account status. So this is not a new requirement. It's just that it now has teeth. It now has consequences if you do not do it on the timeline that's required by the statute. So the changes this year essentially expand the requirement to include a firm timeline, and it also includes things like the translation requirement and mailing the notice to any offsite address provided by the owner plus to the unit or lot address. And it also says that there are penalties for a failure to comply. So if your boards refuse to comply with this, they will be in violation of the statute, which is on its own just a violation, right? But they will also be unable to do almost everything else to collect this debt until they send the required notice. So they will be prevented from charging interest until 15 days after this notice has been mailed. They will be prevented from charging anything more than the first late fee until 15 days after the notice has been mailed. They will be prevented from charging any costs of collection to the delinquent account other than the $10 admin fee that's allowed for the first notice. And they'll be prevented from taking any other action to collect the unpaid assessments, including recording a lien, referring the account to the association attorney, and all the other things that we would normally tell our clients they can do to collect unpaid assessments. So this is not a new requirement. But what is new is that there are penalties for failing to comply with the statutory requirement to send this notice. Now, that doesn't mean that you can't send the friendly notice. You send the friendly notice and you just include a copy of the NOD with it. And you can even say in the cover letter, the only reason we're sending you this enclosed notice is because It's required by statute. You could even say that you don't intend to foreclose at this time or on a short timeline or whatever. We wouldn't want you to say we don't intend to foreclose, period, because then if you do end up foreclosing because the account falls behind by a larger amount of time, you just don't want to put any sort of promise not to foreclose in writing. But you can say, look, we don't intend to foreclose on your home if you cure your delinquency within a reasonable amount of time. We realize that you might have just forgotten, you might have been out of town, you might have had fraud on your debit card and had to change your bank account information. We are only sending this to you because we are required to do it by state law. The required language on the notice of delinquency, I will say, this is one thing to note, is a lot longer than the part that I read out at the beginning of this question. So essentially what the statute does and has done since 2021, and again with the change in 2023, is it prescribes essentially a one-page pre-foreclosure notice of delinquency. If you've ever seen a notice of default related to a mortgage, this looks really similar to that, because it is very similar to that. The language is really similar. The process is sort of modeled after the mortgage foreclosure process. So it's not just a matter of embedding a short paragraph into your normal delinquency notice. You have to actually send the one sheet notice that's required by the statute. So I think that answers the question. If you have any follow-ups, you're welcome to put them into the chat. And Katie, I don't know if you have anything you want to add, but if you do, now's your chance.
No, I think you covered it. So I will go into talking more about when things start to apply. So the next question is there an easy timeline checklist of what needs to be in place for the RCW transition 2025 end dates? So we're assuming that this is talking about all of the WUCIOA changes and when that applies. So as Valerie mentioned at the start of the meeting, for WUCIOA communities, current WUCIOA communities, the changes to the statute take effect July 27th, 2025. For all other communities and for the changes to the collections statute for all communities, those changes take effect January 1st, 2026. We'll get to later in the Q&A today what specific changes will take effect July 1st, 2026 for all communities, but the big one that is going around is the meetings requirement in open meetings. Anything that's not on that list and that doesn't take effect July 27th, 2025 or January 1st, 2026 currently takes effect July 1st, 2028. Now, we don't know what the legislature will do down the road, if they'll make changes that apply January 1st, 2027. But for right now, those are the 3 dates that you need to look out for. WUCIOA for all will apply to everyone January 1st, 2028. If you want to know what applies to your association and when, you should contact your association attorney for specifics on that, if there's anything that is more specific than what we will generally cover here. You don't need to do anything when WUCIOA comes into effect other than comply with the law. So you can opt in early, but it will take effect January 1st, 2028, whether you do anything or not. So other than reading the statute, knowing that it's coming, maybe if you want amending and restating your governing documents to match WUCIOA, you don't need to do anything to transition to WUCIOA unless you want to adopt it early. Many communities are choosing to restate or adopt early to avoid confusion that is going to, and conflicts that are going to exist when WUCIOA does become law. And so at least being aware of those is important. And if you want to transition to WUCIOA early, you can do so with amendment. But you could also restate your documents now, adopt WUCIOA, avoid all the conflicts, and get ahead of the game. Valerie, do you have anything you want to add?
Nope, I think you covered it. Our next question is this: would a trustee for a property in an association be considered eligible to serve as a board member? The short answer to this question is probably, and the longer answer is, a complete answer depends at least somewhat on your governing documents, which obviously we can't answer here. It also depends on how you're defining a trustee. But legally, corporations are considered people, which I always think is funny, but it's true. Legally, they're considered people. And a trustee or a board member, a director of a corporation or an LLC would be allowed to serve on the board if not otherwise limited by your governing documents. And a lot of governing documents don't even require that board members be owners. But if your documents don't prohibit any particular class of owner from serving on the board, and if an LLC or a trust owns a property within the community and the trustee or a member of the LLC or a director of a corporation runs or wants to run to serve on the board, it's almost certainly allowed with some exceptions based on governing documents. So I think that covers the question, but Chelsea, if you want to add anything, I was looking at somebody in the chat. You are welcome to do so.
I'm good. So our next question is, what is the best practice for board meetings and other meeting minutes? I've heard we should only document decisions, but that doesn't provide much utility when it becomes necessary to review specifics of the discussion. How should a board handle this? Additionally, our board would like to document meetings with AI. Are there best practices in place for this as well? So before you do anything, look at what your bylaws say about keeping minutes or the procedure to follow. Sometimes there are specific rules that the minutes should follow that are in your bylaws that is an easy reference. If there is nothing, which is usually the case, it is reasonable to follow Robert's Rules of Order to fill in the gaps where your bylaws are silent. Generally, meeting minutes are only to reflect motions and actions of the board. They're not a transcript of the discussion or of the conversation. But there's no fast and hard rule about what minutes can include. If you think it would be helpful to include specifics about what is said or what is considered, you can. Motions on complex issues, it's usually good to include a list of things that the board considered before making the decision and making the motion. You can include a list, not the contents of what each item has, but a list of, I don't know, the complaint, the report from the architect, the violation notices, whatever it's for. And this can be used to demonstrate the board had adequate inquiry and objective information when they made the decision to basically protect the board down the road that the decision was made properly. Motions should be detailed enough that they don't require interpretation of the discussion. So you shouldn't need to include all of the conversation. If your motion is motion to agree with Bob, that's not a great motion because what are we agreeing about? What was the topic? A more appropriate one is motion to approve green as our front door color based on recommendation from exterior designer. That would be better. If the motion is not clear, then make it a more clear motion at the next meeting. You can revise it. Just note, you can, upon request of specific board members, include that a board member objected to a motion, but they have to request. You don't need to say Sally voted to reject the motion unless Sally requests it. For AI can be a really useful tool for things. We've been getting a lot of AI questions recently. AI is not perfect, so it should not be used as a substitute. You should still review whatever notes AI takes and use it as an aid in the creation of the minutes, not as a substitute for the creation. And it's certainly not an official record of the association. And that's also important. We ran a training through AI and it created a 60-page outline of, I don't know, probably a 4-hour meeting, which I took hand notes on, and it was 11 pages. And so there was a lot of fluff that AI includes, and also apparently it went on a tangent about, I don't know, like social justice, which was not on topic at all. And so it is really important. While it can be useful, you have to edit it. It is still not a perfect system. And so just do with it what you will. Valerie, anything to add?
Yeah, I mean, I think further to the discussion on AI, one of the things that I've just read an article yesterday, I think, about it, which was, why do attorneys keep using AI? Because when it was yet another example of some attorney in another jurisdiction that had been censured by their state bar for using AI to draft pleadings, because the AI just like made up cases that don't exist in support of whatever the position was that they were taking in the motion. And so AI is improving rapidly over time, but it still gets stuff like categorically wrong, and it still makes crap up sometimes. And so I think I would suggest that if you're considering using AI to assist you in sort of understanding or remembering what happened during a board meeting, you would use it similarly to how somebody might use a video. So if your board secretary or your manager is the person responsible of producing the minutes, and they keep a recording of the meeting so that they can go back and double check their notes to make sure the minutes are accurate, that's one thing. But relying on the transcript created by AI, or relying on the recording as a substitution, as Katie said, for actual minutes drafted by a person, is something we would strongly recommend against. And
Valerie,
when it comes to retaining either the video or the transcript, our recommendation generally has been that that is actually not a record of the association. It is something that's created for the personal use of the person who is taking the minutes, who's responsible for taking the minutes, and that they should be deleted or destroyed, whatever, once the minutes are approved at the next meeting of either the board or the association, depending on, what the scenario is. Katie, did you have anything else on that one?
I was just going to talk about what you just mentioned about retention. So
okay,
I'm good.
Perfect. All right, here's our next question. We are trying to understand the timing of the changes made under Senate Bill 5129. Just as a reminder for everybody, 5129 is the one that we've all been calling the WUCIOA trailer bill. So it's the bill that made additional changes to WUCIOA. The question goes on to say, the heading indicates changes to RCW 6490 are effective July 27, 2025, except for a few specific sections that take effect January 1, 2026 and January 1, 2028. In particular, we are trying to determine if the obligations of RCW 6490-640 to provide a resale certificate take effect in July of this year. We are an HOA governed by RCW 6438, and currently we do not have to provide a resale certificate. We are an all-volunteer community and don't really have anyone qualified to prepare a resale certificate, and we thought we had until January 1, 2028 to address this issue. Can you provide clarification? So, for non-WUCIOA communities, most of the changes will not apply to you until WUCIOA for All takes effect on January 1, 2028, and this includes the resale certificate section for RCW 6438 communities. So you do have until January 1, 2028 to get this figured out. However, I do want to point out that the statute itself gives you a roadmap to creating a resale certificate, because you can literally copy and paste the resale certificate section from the statute into a Word document, answer the questions that are there, attach the documents that are required, and you will have a resale certificate. So it does not have to take a specific form like you might see from a website that produces these, like HomeWise. We also have had clients that have asked us to prepare essentially a template for them to create a resale certificate. And so if you have an association attorney that you're already working with, this is something that they should be able to prepare for you as well. So I guess what I want to say before I get further into what applies to who and when is, creating a resale certificate is not as hard as you might think that it is. It's daunting anytime you have to do something you've never done before that seems really complicated, but the statute itself can serve as a checklist. And I think once you do one or two, you'll realize that it's a little bit more straightforward than you might otherwise think that it is. So that's not to say there isn't work involved. It's not to say that some of these new requirements don't impose, an additional burden on board members who are all volunteers, most of whom have full-time jobs and a life. And you guys give a lot of your time. And so I don't want to downplay the value and the significance of the times that y'all are donating to your communities. All right, so moving back to the question of what applies to who and when, I covered the part that non-WUCIOA communities are mostly unaffected by these changes until January 1, 2028. For WUCIOA communities, most of these changes do take effect this year, July 27, 2025, except for, if you look at the bill itself, sections 2 through 4, 11, 19, 21, and 25 of the bill don't take effect until January 1 of 2026. And I'm going to copy and paste into the chat, or Katie beat me to it. Somebody beat me to it. This is a following list of the changes that are going to apply to all communities starting January 1 of 2026. So these include the section that talk about what applies to pre-existing communities and when. It includes some changes to the powers and duties of the association. The meetings section is one of the big ones. The meeting section, which is RCW 649445. These changes are going to take effect January 1 of 2026, not just for WUCIOA communities, but for everybody. And so that's a big one for y'all to be paying attention to. And like I said before, CA Day is coming up in, is it September or October? I already forgot. In the fall.
October 18th.
Okay, thank you. And one of the presentations that somebody from our firm, Katie, I think, is going to be pitching with a manager who has lots of experience with this stuff is like, what the heck do we do because of these meetings statute changes? So I strongly encourage folks to attend CA Day. I think we're going to see a lot of education at CA Day about these changes to the statutes. On the list, it also includes, there's one subsection of the assessments section that is going to apply to everybody, January 1 of 2026. And that is that associations have to provide owners with at least one cost-free method of paying their assessments. So I know a lot of communities and a lot of management companies and softwares have been moving towards different online payment methods, including, credit card payments or whatever, some of which have convenience fees or other fees attached to them. But every community has to provide their owners with at least one method of making payments that does not cost the owner any money. So that might mean that if you've refused to take checks, but you don't have an electronic payment method that doesn't charge fees, that you have to start taking checks again. So that's one to keep in mind. Subsection 502 or section 502 is the emergency section of WUCIOA, and that is going to be applicable to everybody because the meetings changes are applicable to everybody. And so you need to read that section really carefully to understand when an emergency actually applies, because spoiler alert, it's probably not all the times that you think of as an emergency, right? The statute very clearly defines emergency, and that is, it's there for the purpose of telling us when we can have board meetings upon a shortened amount of notice to the owners. And it's pretty rare, let's just put it that way without going into details of the actual statute. 513 is the EV charging station section. 525 is the budget ratification section, which already applies to everybody. So this is not a new change. 545 is reserve studies, also already applies to everybody. And then 580 is changes to the heat pumps section of WUCIOA. So again, that list is in the statute. These are all of the sections where the changes take effect on January 1 of 2026. And apply to all communities at that time, not just to WUCIOA communities. So if it's not on this list, and if you're not a WUCIOA community, again, you have until January 1 of 2028 to understand all of the changes that you are going to be subject to, and to work your way towards compliance with those changes. Katie, did you have anything to add there?
The only thing I'll add is that all 4 statutes already have language about heat pumps and EV chargers. So that's not going to be that big of a shift. They're just some minor changes that I think they wanted to stop updating all of the other statutes. So if you're already basically prohibiting these things, maybe check with your association attorney, because there may be an issue there. Okay, our next question is, an owner was a board member for weeks after the date an important document was received by management. Due to a clerical error, it was not forwarded to board members at the time. Subsequently, for unrelated reasons, that member resigned. Is that former member still entitled to see the document in question since it was received during their tenure? The short answer is no, they're not entitled to the document, at least not for the reason that they were on the board when the document was received. They may be entitled to the document for other reasons, but it's not because they should have gotten it while they were on the board and they didn't. Once someone is off the board, they must follow the records request process like all other owners. RCW 6490-495, which is the record statute in WUCIOA. It's mostly similar in all the other statutes. It lists what owners can request and what must be redacted and what records the association must retain. Now, we don't know what the document is, and we wouldn't be able to advise on it, even if we did, as to whether or not it should be provided. But the statute's basically a checklist of what documents you have to have and what documents you have to give if they're requested. A former board member does not get special treatment just because they were on the board when the document was received and it should have been distributed. When documents are given to the board, it's for the board to work and review the document as part of their board work. It's not because they're an owner with advanced warning that gives them permission to get the document. We don't know why the former board member would need the document now. If it's a record that the association is required to keep and that they are entitled to request as an owner, then it must be provided, but there's no other reason that they should have it if they're no longer on the board. Valerie, anything to add?
Nope, I think you covered it.
Great. So our next question is, our King County Charter prohibits any parking on our private roadways, but it happens all the time. How do we enforce these parking violations fairly and equitably when there are so many and we don't have an on-site manager? As an alternative to enforcement, would it be reasonable to empower owners to put standardized friendly notices on windshields when they see a vehicle parked on the street? Just for clarification, we're assuming when you say King County Charter, you mean your CCNRs or declaration recorded in King County. If it's some other King County ordinance, this will not be a helpful answer. So generally, all violations must be enforced uniformly given the circumstances. But the board cannot enforce violations that it doesn't know about. So obviously, you're not going to be able to get every violation at all times whenever. As we've talked about before, boards are volunteer, you have lives, you just basically have to do your best and investigate known violations and then take appropriate action. Owners can report parking violations to the board with pictures and timestamps of the violations. There's nothing that would prevent an owner from putting a notice on a car that is already in violation of the rules. Whether or not you can take enforcement action based on that notice is a different question. But I mean, anyone can put anything on a car. You get it all the time at the grocery store. We don't know for this community if there are no parking signs or how fleshed out the rules are for parking, but the board is the one who determines if a violation exists and what enforcement action to take. And this is after an independent investigation based on objective information and adequate inquiry. So while an owner could put a notice on a car that they have to move it, that's different than the board being able to find a violation and assess a fine after notice and opportunity be heard, or even tow the vehicle. You could have an owner volunteer to roam the community and take pictures of violations for the board to consider. We do have clients with parking patrols that walk the property and cite cars that are in violation. That's different than a goodwilled owner just putting post-it notes on cars. The board could form basically a committee that delegates some authority to a more formal parking patrol. If you don't have clear rules about parking, consider adopting a parking policy and procedure for how to deal with enforcement, who can write notices, how it goes up to the board, how violations are done, where people can park. Um, if you want assistance with this, you'll need to contact your association attorney for more specifics, because also a lot of people think their roads are private when they're not, which is a whole different can of worms. Valerie, do you have anything to add?
Yeah, the only thing that I would say is one of the, part of the question is how do we enforce this fairly and equitably? Also, given the fact that you can't be everywhere all the time. And I think one distinction that it's important to understand is that just because you can't enforce against everybody all the time does not mean that the enforcement action you do take is not fair and equitable. As long as your policies are clear and you are dealing with the enforcement or the violations that are reported to you in a fair and equitable, uniform manner. So the fact that you can't be everywhere 24/7 catching every single violation does not mean that you can't enforce against anybody ever. It's not all or nothing. It's you're doing the best that you can with the information that's available to you when violations are reported to you and you have the information that you need to take enforcement action. And the other thing that I think it's important to note is, and I apologize if you covered this, Katie, but there is in WUCIOA at least a provision of the statute that says that the board has the authority to determine if taking enforcement action is not in the best interest of the association. That's within the board's discretion to make that decision. So if you decide that this is more effort than it is worth to be super proactive and detailed in your approach to enforcement with respect to parking on these private roads, assuming that they are in fact private, like Katie's comment alluded to, that is within the board's discretion. But I would say if you're thinking about taking that approach, that is definitely worth a quick consultation with your association attorney. And in particular, ask them to tell you how to document that decision so that you have proper documentation for the board's decision that enforcement action in this particular area is not in the association's best interest.
Or
Katie, did you have anything to add?
I just want to add on the documentation. It's also especially important if you are choosing that enforcement is in the association's best interest, especially for towing, that's documented and you follow very specific rules. So basically, if you're concerned at all about your parking and towing and enforcement and anything like that, and you want to know what to do, contact your association attorney.
Yeah. And as a general aside, I know we say that a lot, contact your association attorney, but number one, I think you all understand that part of that is because we can't give legal advice here. And a lot of these questions, you all would benefit from actual legal advice. But the other reason that we say that is because when you ask for and receive an opinion from your association attorney on something, and you rely on that advice in making a particular decision, number one, you are following through with your duty of care to act with, rely on objective information and engage in an adequate inquiry before you make your decisions as a board. So you're discharging your duty of care as board members to do that. And number two, there is at least some shifting of risk from the association to the law firm when you get a written opinion from your attorney and then you act on the advice of your attorney. If that ends badly in some way, there's at least some shifting of risk there in having secured that opinion. So you're not just paying us to tell you things that you already know, right? You're paying us for a lot of different reasons. Number one, to tell you the things that you don't know, but number two, also for that risk shifting. Okay, I'm going to move us on to the next question. Can owners expect the board to be the cops of the neighborhood? Some think that we should patrol for things like dogs not on leashes, dog poop offenders, etc. How do we explain to them? And can you give us some resources to explain that that is not our job? So, I obviously, as the person who submitted the question alludes to, no, this is not your job. You are absolutely not intended to act as the cops of your neighborhood. And just like we covered in the previous question and answer, the board does not have an affirmative obligation to go out and look for violations that it does not know about. We've heard stories about HOAs that use drones to fly around the neighborhood and look for a violation in somebody's fully fenced backyard. that is not something that you have to do. And I think I can't point to a specific resource other than I do think that encouraging homeowners to take advantage of resources like this Q&A, like the WSCAI education opportunities, including the journal, or even the WSCAI website. What I would say is part of how you handle this is in how you communicate to your ownership. And some of what you say is what I just said earlier. You guys are volunteers with full-time jobs and families and lives. And it is not required either by state law or by your governing documents that you be out there patrolling for violations. And I think also if you sort of flip this issue back onto the owner in question, they're like, well, you should be doing this and you should be doing that. Usually that's because that particular owner has an interest in a specific thing. They want you to be out there looking for the dog poop because it irritates them when they see it. But I can almost guarantee you that that particular owner is also probably doing something that in certain scenarios could be described as a violation as well. And they probably don't want you out there investigating that thing. So whether it's because they don't bring their trash cans up from the curb fast enough, or whether it's because, I don't know, their window coverings are the slightly wrong color, or whatever it is, right? Nobody's perfect. Living in community has challenges, and people are going to annoy each other the more they live in close proximity to one another. And your job is not to be out there eliminating every annoyance to every owner, because A, that would be impossible, and B, this is a volunteer gig and the pay sucks, right? This is the joke. So I think that's how you communicate it with your owners. You can tell owners that they're free to report violations to the board in accordance with any policies that you have, and that the board will investigate reported violations. But I think there should also be, if you're going to consider reminding owners of that, you should have a clear policy of how owners report violations, what information the board needs in order to investigate a complaint. So in other words, if somebody drops an anonymous note in the mail to the board about somebody's food smelling bad to them or whatever, I don't think that creates an obligation to investigate. On the other hand, if somebody sends you photographs of what is a clear violation, I think that probably does create at least a duty to inquire and to investigate whether that violation is something actionable by the association. And then finally, you can also remind people, if they just don't listen to any of this stuff, you can remind them that they have the right to sue their own neighbors for violations of the CC&Rs if they don't think that the board is doing enough. So I think it's worth saying that in many communities, there are always a handful of owners or one owner who just, what you do as a board member is never good enough. It's never enough. And trying to make those people happy is an exercise in futility. So I also think sometimes the right answer to this is that you essentially do what I do when my kid was little, or did when my kid was little, and would ask me the same question over and over and over again. I just started saying, I've already answered that question. Asked and answered. And she found it infuriating, but it helps me be less annoyed, because then I didn't have to answer the same question over and over again. And so maybe that's part of your strategy. Part of your strategy can be like, we've already had this conversation. The board is not going to address it again. So Katie, did you have anything to add?
I did. My dad did ask and answered to me all the time.
Is it a lawyer thing? Maybe it's a lawyer thing. I don't know.
Lawyer thing. The only other thing I'd add, which is, and this kind of came up just now in the chat, is how about requiring them first to talk to the other neighbor with whom they're reporting the violation? You don't need to require it, but you can certainly, you're still a community. You can still encourage neighbor to neighbor communication if it's appropriate. So if it's the neighbor next door is not picking up their dog's poop and their dog is pooping in the front yard, you can say, hey, you can talk to them. There's also I would say for lower stake things, it's more appropriate, more neighbor to neighbor disputes. There's the WSCAI mediation program, where if you just have, okay, Bob's letting his dog poop in Sally's lawn, but Sally won't mow her lawn, they can duke it out in a mediation that is maybe more appropriate in this certain setting.
Yeah, agreed. So there's some follow-up questions in the chat, and I think we have time to jump to them before the very last question. One is, What about pet violations? Does it need to be documented that the board chose not to act on a pet complaint? Do you want to take that one, Katie, or do you want me to run with it?
I'll start with it. I would say anytime the board, for any type of violation that the board chooses not to act on a complaint, I would document it. I don't see the reason not to. I would show what you considered. And especially for if it's a pet complaint and the pet is more of an aggressive dog that you may think may be more risky, then yes, definitely document it. The more documentation for the more risky violations, risk being you chose not to act and someone will complain or something bad would happen, the more documentation, the better for anything. Valerie, anything to add?
Yeah, I think the answer to this question that it depends what the pet violation is. If it's because somebody's dog is pooping on their neighbor's lawn, I think that you can, that is an easier, lower stake thing to defer enforcement on or to choose not to enforce. And it also depends on a lot of other things too, like the size of your community. If you're a 3,000 home HOA, I'm sorry, but there is no universe in which it is practical that the board or an employee is going to go around and check all 3,000 lawns to make sure nobody's dog is pooping on their neighbor's lawn, right? If it's a dog that's barking all night long or a dog that's being physically aggressive, I think it's a very different question. And anytime you're going to choose not to enforce the governing documents, I would just check in with your association attorney to make sure they don't have advice for you about, like, here are the questions you should answer before you make this decision, or here's how you should document this decision in your board meeting minutes to protect the association as much as possible. The next question, also enforcement related: can a board enforce a non-smoking policy, such as no smoking that disturbs the neighbors, if the person accused of smoking says that they don't? We're currently treating it as a dispute between owners and not an HOA matter. I'll jump in on this one, and I'm sure Katie might have something to add. You have the right to regulate what owners do in the common areas and the limited common areas. Your right to regulate what they do in the privacy of their own home is not unlimited. And if somebody is smoking in their unit in a condo association, for example, this is even more true in a single family home community, you certainly, there is, that section in the declaration that says nobody shall do anything in their unit that's noxious or offensive to a neighbor, but smoking is legal. And so unless you're going to adopt an amendment that allows you to ban smoking within the units, you have to balance the interest of enforcement to protect a neighbor, for example, from smoking neighbors, like noxious fumes or whatever, with the owner who is smoking in their unit and their right to use their unit how they want to use it, or how they want to use it. So I'm not going to answer this question about whether you can enforce a non-smoking policy, because number one, it's not a non-smoking policy unless you have a non-smoking amendment, like a smoking amendment ban, whatever, smoking ban amendment. And number two, it's complicated because it depends on the layout of the community, what the impact is on the neighbor, how many neighbors have complained, whether it's, all the surrounding neighbors or just one person, because I am extremely sensitive to cigarette smoke. Enforcement based on my complaints would probably be an unreasonable standard, I think, in a multifamily housing situation. But if somebody is literally chain smoking in their unit all day long and all the neighbors are complaining, the answer might be different. So that's a very long non-answer to the question. But Katie, did you have anything to add?
Just two things. I think, as you said, it boils down to who's complaining. And I think that gets to the board's obligation to investigate. And so if I don't think it's reasonable to take the complaint of one owner and say, oh, it's a violation, especially if the person being accused of the smell or whatever the conduct is saying they don't. And you don't have anything to back it up. That's just a person to, like, I don't want to say he said, she said, but whatever the equivalent of that is. So the board has to actually investigate beyond, especially for these things where people may have different sensitivities. The board has to investigate what a reasonable person would consider to be a violation, not just the comment of one owner. Also, just as an aside, courts have held that smoking cigarettes is not considered a nuisance. So if you are trying to use the no nuisance in the community, you're not going to get there with cigarette smoke. They haven't talked about like weed or marijuana smoke, but I wouldn't want to have to be the one to try and argue that weed is different than tobacco,
Yeah,
scent wise.
especially in a state where it's marijuana use is legal.
Yeah.
I'm going to jump us to the next question because it's our last one. And I think it sort of previews an answer to the executive session comment in the chat, even though the topic of the question is a little bit different. If a board can go into executive session to discuss contracts or hiring or firing of employees, are landscapers considered employees or contractors? Landscapers are usually third-party vendors. So discussing a landscaping contract would generally not be something to discuss in executive session. The exception would be if you are competitively bidding a landscaping contract or project, or if your community actually directly employs a landscaper as an employee of the association. So this would not apply, executive session would not apply if you're talking about a problematic employee of the landscaping vendor, if you're talking about whether they did their job fully last month when they were out, whether you're talking about we want them to come every 2 weeks instead of once a month. Those are all things that should be discussed in your normal/open board meeting session. So RCW 6490-445 subsection 2B is the portion of the WUCIOA meetings section that talks about executive session. And on January 1st, 2026, this whole part of WUCIOA is going to be applicable to everybody. So keep that in mind, and you can start complying with this now as non-WUCIOA communities, even though it doesn't directly apply to you until January. And what it says is there's a specific list of topics that are appropriate for discussion in executive session, and they include consulting with the association's attorney about legal matters, discussing existing or potential litigation, mediation, arbitration, or administrative proceedings, discussing labor or personnel matters, discussing contracts, leases, and other commercial transactions where premature general knowledge of those things would harm the association or put the association at a disadvantage. So that's what we're talking about, like competitive bidding of a project, for example. And then any other issue where preventing public knowledge of the matter to be discussed would violate the privacy of any person. And I want to say something about that particular sort of what feels like a catch-all provision. That is, just like I said earlier, what we all think of as emergencies are not what the statute defines as an emergency. Violating the privacy of a person doesn't just mean that you think it should be private and therefore it's appropriate for executive session. This is talking about things like, is somebody part of an address confidentiality program, and would discussion of their situation potentially put their privacy, their legal privacy, and their safety at risk? That's the kind of thing that could fall under this provision. If you're talking about something that's like sensitive issues dealing with a minor within your community, I think that could be appropriate for inclusion in executive session. Katie, you looked like you had a comment you might want to.
I was just going to add, I think discussions of requests for reasonable accommodations or modifications may fall into that category.
I think that's a great example. Yes. So unless the topic is one of these listed items, it's not appropriate for inclusion in executive session. And also, I want to remind you all how executive session works. Executive session is not a whole separate meeting that you don't notify your owners about. It is something that happens during a regular board meeting. So in your regular board meeting, somebody makes a motion that I move that we adjourn to executive session to discuss the attorney's memo and this employment issue that we have to discuss. And somebody seconds the motion and it carries, and then you adjourn to executive session, which is where you do not have to allow owners to observe if you're in an open meeting community, which we all will be in January. And then during the executive session, you do not make any motions or take any board votes. You have your discussion, and then you come back into your open board meeting, and that is where you vote on the topics that were discussed during executive session. So as to the specific question that was asked, I think a landscaping situation is almost never something that would be appropriate for executive session unless you are competitively bidding a project or something like that. but hopefully that primer on executive session is helpful more generally. And Katie, I don't know if there was anything else you wanted to add to that.
Just to the specific question of, do executive sessions need to be, because that came up in the chat, documented? Just reiterating, you're only documenting the decision outside of executive session. You don't take notes or document the discussion had an executive session, because that would, in my opinion, defeat the purpose of the executive session if you then have the record of it after. But
yeah, that's fair. Okay, well, we have a few questions from the chat that we can get into. So I'm going to start with the first one, which is there a legal obligation to send a proxy via mail for a special assessment budget meeting? And I started that one because it's short and easy. And the answer is no, you do not have to send a proxy to the owners with your budget ratification packet for a regular budget ratification or for a special assessment budget ratification. Did you want to add anything to that, Katie?
nope, I don't, that's it.
Okay, we like the easy ones. There was a follow-up question regarding the pre-foreclosure talk that we had at the very beginning, which is, so first notice of delinquency with the pre-foreclosure notice of delinquency, does that apply to like a short payment of approximately $10 or $20 or unpaid late charges or violation fines? You know, I would say those three things could be really different. If the balance due is $10 and you're not even sending a delinquency notice, then no. But you do have to keep in mind what the statute says, which is that until you send that first written notice of delinquency, including the pre-foreclosure NOD, you're limited to one late fee. You're prevented from charging interest until 15 days after that notice has been mailed. And you're prevented from taking any other collection action or assessing any other collections costs to the account. So it sounds kind of ridiculous if you're talking about a $10 balance due. And what I might say as a practical matter in a situation like that is, and it would depend, I suppose, on the context, the composition of that $10, if it's a penalty versus, you know, a short payment from a month ago versus a short payment from a year ago. One possibility is to just write it off and bring the account to a zero balance. So you remove the delinquency and remove the issue entirely. Another option is you just don't send that first notice, understanding that you're limited from doing those other things until 15 days after you have sent that notice. And if you have specific questions about any particular accounts, consult with your association attorney so they can give you advice on how to handle any particular account. Anything to add, Katie?
Nope.
All right, next question. Proxies are popular today. Are proxies legally required to be sent with special meeting notices? Do you want to take that one?
I think we just already answered that, which was no.
Well, we answered it in the budget ratification context.
Oh.
And I wondered if we thought there was a different answer for special meetings.
I say no.
I agree.
There's basically no there's no obligation to affirmatively send out proxies. The question of whether or not you have to accept a proxy is different, and proxies are different than absentee ballots. So for the proxy question, no.
Yeah. Agreed. So we're running close to the end of time. There were a couple of questions in the chat about a road with right-of-way and fences and encroachment, and that is too specific for us to handle in the context of this Q&A. Those are the kinds of questions that you need to submit to your association attorney. So we're not going to be able to answer that question. The last one that I'm seeing is, where can we find info on any case law where courts found that smoking is not considered a nuisance in common interest communities? Katie, do you know that one off the top of your head?
I don't know it off the cuff, but I know where to find it. So I'll give it to Chelsea to update, to add to like as an update for the next Q&A.
That's great. And if you're giving it to Chelsea anyways, the person who asked this question, you can email info@condolaw.net and Chelsea can email it to you as well. So I think that takes us to the end of our Q&A for today. We're happy to have been here with you all. Thank you for joining us, and we'll see you next week. Bye, everybody.